It is only that organ that is capable of executing that particular function. And for the question of further delegating that particular function cannot arise so as to say that the Deputy Chief Justice had the constitutional mandate to appoint this bench to adjudicate over these particular files. Your Lordship, we have put up a case that the Deputy Chief Justice has not only violated the Constitution, but also violated the rights of the petitioners to be heard under Article 50 of the Constitution. When they moved to appoint a bench of this, the bench, and failed to notify the parties herein as evidenced by the counsel appearing for the petitioner in petition number 14, it tells your Lordship that the expediency for which it was done was so as to meet the objective of setting aside the orders that were granted by your brother Justice Mongo and your brother Justice Mwita. Your Lordship, when you retire to make a ruling of our application, it is important that you pay serious attention to paragraph 12 of our affidavit, paragraph 21 again of the affidavit, paragraph 22 again, and also paragraph 27. And then you might want to ask yourself, under section 10 of the High Court Organizations, High Court Administration Organization Act, how, under what circumstances, the Chief Justice, the Deputy Chief Justice, authorize you to sit on a Saturday? Under what circumstances did the Chief Justice herself, Deputy Chief Justice herself, sit at night, in the wee hours of the night, ungodly hours, and constituted this bench? Your Lordship, is our humble submissions that Article 10 has only arrogated that function again exclusively to the Chief Justice, and that the Deputy Chief Justice has no power under Section 10 of the High Court Organization and Administration Act to order you or to authorize you to sit on an odd day like that or the Saturday. Your Lordship, permit me to draw your attention again to the case of Omtata. When you retire and the judgment will be highlighted by my learned friend, it is of importance, Your Lordship, that you look at paragraph 192 of that judgment. It has given the circumstances under which the Deputy Chief Justice can act in the absence of the Chief Justice. One is if the Chief Justice is indisposed, if he resigns, if he is dead, or if he is ordered out of office. The question of leave, to which we are submitting without knowledge whether that is the circumstance that led to the allocation of powers by the Chief Justice, is not one of the grounds or reasons that the Chief Justice can exercise, the Deputy Chief Justice can exercise the exclusive powers meant for the Chief Justice. Finally, Your Lordship, all these avowals contained in our affidavit have not been controverted by the respondents through a replying affidavit. They have only filed the grounds of opposition, to which they shall bring to your attention the case of Container, which has been distinguished by the case of Okia Omtata. The grounds contained in our affidavit, Your Lordship, are uncontroverted and they must be admitted as such. I beg to rest my case.
May we request counsel to give us specific reference to Okio Matata has been mentioned by two counsel. He's probably the most prolific litigator in the history of Kenya, so we don't know which of his many cases are you referring to.
I will certainly be addressing my senior at the bar, senior at the academy, Professor Gideon Mugai. It is a pleasure being with him in court. A man or woman who plants a tree, not knowing fully well that they will not sit in its shade, knows the meaning of life. You sit today in such an epochal moment that what you do here has significant ramifications for the Republic of Kenya. It is for you as a court to rise to the occasion. This court has defined the Constitution as a transformative constitution. And this was done by this very court, differently seated in the BBI case, David D. and others, versus the Attorney General. And this is what the court said about the Constitution 2010. It is a constitution of a transformative character. And this transformative character of the Constitution induces large-scale social change, including the character and conduct of politics. That the Constitution bears an internal theory of interpretation. Starting point for discerning that internal theory is Article 259 of the Constitution. That formalistic approaches to constitutional interpretation are not favored. And lastly, that the Constitution has provided for its own theory to protect its values, objects, and purposes. That is what is before you as a court today, that you are supposed to maintain that innate character of this Constitution as a transformative charter. The other side has filed grounds of opposition, and in their grounds of opposition, they raise a case, Lorna Conchela and others versus the Chief Justice. That was the grounds of opposition by the Attorney General. And in that case, this High Court said that the power to appoint a bench is administrative, and that power can be performed by the Deputy Chief Justice in limited, constricted circumstances. So that the normative holder, the Chief Justice, performs it, but the Deputy Chief Justice has to perform it in certain limited circumstances. Those limited circumstances have to be demonstrable. That is Conchela. Your Lordship Justice Murima, sitting in Okoiti versus JSC and another petition, E408-2020, 2021 EKLR, I believe that is what Professor Gideon Mugia was asking about. Paragraph 2938. Justice Murima finds that the authority under Article 165.4 is a constitutional authority, so that authority cannot be delegated by the Chief Justice, because the Chief Justice does not cease to be a state officer, even on leave. We have another authority here, Petition 31 of 2013, Kenya Medical Research Institute versus the Attorney General. This is found at 2014 EKLR at paragraph 37. Kenya Medical Research Institute versus the Attorney General and three others, 2014 EKLR. This case at paragraph 37 says this, that the Chief Justice under Article 165.4, the authority to empanel a bench, performs a constitutional mandate. And this is not an administrative function, as was in the old Constitution. Where do we go? I'll invite the court to look at the express wordings of Article 259.3a that expressly decrees that authority granted to a specific office must be performed by that specific officer. That is Article 259.3a. Allowing this court to consider the decision of the Court of Appeal, and this, the other side can take judicial notice of, the court can take judicial notice of the case of Karisa Chengo, whereby the office of judge and the person of judge are synonymous. So that the Chief Justice, the person, and the office of Chief Justice are synonymous. And therefore, we cannot separate and delink the holder and the person. And therefore, if the Chief Justice were to delegate any responsibility to the Deputy Chief Justice, assuming that was possible, then the Deputy Chief Justice has to take an oath by virtue of Article 74 of the Constitution. There has to be instruments prepared authorizing the DCJ to act as Chief Justice, and for what purposes? Ladies and gentlemen, honorable court, the Greek tale of Ulysses, the coxswain who was asked to block his ears using wax and to avoid the temptation of alluring music, that story echoes well for you today. It's politics, there's a lot of heat and rancor, but for you, as the court, an apex court under the Constitution, yours is to uphold and defend this Constitution as required at Article 3. That's the sole mandate of this court. Thank you.
My lords, my ladies, I stand here to argue the supporting arguments for the first substantive petitioner, His Excellency, the Deputy President. And in the 10 minutes given to us, I will take 7 minutes and leave 3 minutes to my learned senior colleague, Senior Counsel Paul Mwite, who is his to take the lead in arguing this point. Allow me to begin by juxtaposing 3 constitutional provisions, then pose the challenge that I will ask my lords to retire with for purposes of your consideration. The first is Article 141, Clause 1 of the Constitution. Article 141, Clause 1 of the Constitution provides, and I read, that the swearing in of the President-elect shall be in public before the Chief Justice, or in the absence of the Chief Justice, the Deputy Chief Justice. It's very clear. It says who must do and what will happen in the absence of that person. Article 148, Clause 4 of the Constitution provides, and I quote, the swearing in of the Deputy President-elect shall be before the Chief Justice, or in the absence of the Chief Justice, the Deputy Chief Justice, and in public. Another very clear stipulation of our Constitution of what the Chief Justice can do and what will happen in the absence of the Chief Justice. Then we go to Article 165, Clause 4. I want to emphasize one thing, my lord, my lady. You notice that Article 141, Clause 4, Article 148, Clause 4 come before Article 165, Clause 4. The makers of the Constitution were aware of what would happen in the absence of the Chief Justice while drafting Article 141, Clause 1, Article 148, Clause 4. Let us see what they said at Article 165, Clause 4. They said, and I quote, that any matter certified by the court as raising a substantial question of law under Clause 3B or D shall be heard by an even number of judges, being not less than 3, assigned by the Chief Justice, full stop. I'm always encouraged by an article my mentor, Professor Balindiway wrote many years ago called Political Jurisprudence or Neutral Principles. Another look at the problem of constitutional interpretation. And Professor Balindiway makes an important argument that decisions of constitutional courts must be formulable in such a manner that they would apply coherently to all subsequent cases of similar facts. I'll not read these names in full, but you now know that if we approach this court and read for it Lena Conchella, the decision already alluded to, it will appear that this court's position is this power by the Chief Justice is administrative. If we approach this court and read the case of Kemri and the case of Montata, both of which have been referred to by my learned colleague, Mr. Gada, you'll notice that the power under Article 165 is not administrative. The court says so, and my Lord Judge Murima, you contribute that jurisprudence. It is a constitutional imperative. I think my teacher, Professor Gideon Mwiga, would frown at that in jurisprudence as being political jurisprudence, because then we cannot answer first year law student coherently. Is it administrative or is it not? We will find it difficult to answer it. Fortunately for you, as judges sitting here, you are not bound by those previous decisions, and you must come to the correct interpretation of the law in a manner that would address similar cases in the future coherently and without subjecting the judiciary to possible embarrassment. So then you will have to go and read what the two cases say, Kemri and Oltata, constitutional imperative, and what Conchella says, administrative. But then you look at the eventual verdict in Conchella, even when they say it's administrative, they set out the preconditions for that. And the question you want to answer is this, my lords: have those preconditions even been met, assuming even that you take it by administrative, for the Deputy Chief Justice to take up the tools of constituting a bench? Because that's a limited question that we are here to address and to guide this court. I make an argument that none of those grounds has been met. For example, we sat in this court in the morning, and I know this question will arise subsequently when we deal with the application for recusal, where my lords say, no, in the virtual courts, in the virtual system, we can sit on anywhere. I'm trying to paraphrase it, my lord, so if I get one word wrong, it's not for any ill intention. We can sit at any time. We can sit from anywhere. We can sit on any day. So that, can the Chief Justice, for example, be virtually absent? Is it possible that the Chief Justice of Kenya distinguishes herself as the first person to be absent virtually? Wherever she is, at home, in Europe, in Asia, in Australia, Kenya, wherever it is, can she be absent virtually? The answer is an emphatic no. That in the virtual space, it is difficult to justify absence. Is the Chief Justice disabled? At least, it has not been suggested by the applicant, nor the respondent, that the Chief Justice is disabled. And therefore, even looking at the Conchella decision, none of the preconditions cited there to justify the limb of administrative has been met. In which case, the Deputy Chief Justice has no basis upon which she could have taken up the charges to constitute this bench. In a virtual court, my lords, and we must be very careful about this, because I kept asking myself this morning, I've never been a judge, maybe one day I will be, maybe not, how uncomfortable it would be to sit as a judge when you perceive that some of the parties believe are uncomfortable with you. It must be a very frustrating situation to find oneself in, and my sympathies go out to all judges who find themselves in those circumstances. That's why I'm making this argument. But the interface between litigants and the judiciary in this technology space is the CTS, the e-filing system. There are no directions from the Deputy Chief Justice in the e-filing system that we are interacting with. None whatsoever. Is the judiciary immune from the principle of transparency and accountability? It is not. If the Deputy Chief Justice makes such a consequential move as taking up the powers vested expressly in the Chief Justice, that's a matter she must, number one, expressly disclose by lodging it in the CTS for us to interact with. Number two, provide reasons for taking up that role. In that direction, we ought to have seen a decision saying, for the following reasons, I take up this role of the Chief Justice, then proceed to give direction. In the absence of that step, my lord, you have stood up as individual judges, as some of the greatest defenders of our Constitution. That character you have established in the past demands that you look at the Deputy Chief Justice in the eye and say, you may have been well-intentioned. You are. you fell short of the constitutional standard, and therefore by virtue of Article 2 of the Constitution, what you did was null and void. Our seating, the three of us at this bench, is null and void. We must down our tools at that juncture. Allow me to invite my senior colleagues, senior counsel permitted, to carry forward and finish our arguments. And thank you so much.
I will be very brief, Lords, Your Ladyship. The taking of the court file 015 from Kirinyaga Court in the middle of the night was a gross irregularity that impacts on a fair trial. The bringing of that file in the middle of the night from Kerugoya, presumably the Deputy Chief Justice, was another gross irregularity. For the Deputy Chief Justice to have sat in the middle of the night on Friday, the 18th of October, was a gross irregularity. The absence of communication from the Office of the Deputy Chief Justice to the parties in 015 was a gross irregularity. For your lordships and your ladyship to have sat as a court outside the prescribed court days on a Saturday was a gross irregularity. The maxim that justice must not only be done, it must manifestly be seen to be done, is an extension of the right to a fair trial guaranteed in Article 50. This litany of irregularities contaminates the sitting of this bench irredeemable. And I would ask that in respect to Article 50, we do not even go into issues of recusal. Your lordship, your ladyship should, on the basis of those irregularities. Now, there is one I have forgotten. When this honorable bench was hearing our plea for an early date, this honorable bench said the earliest date they had was Thursday of this week. So now, with this litany of irregularities, this honorable bench found time to give a hearing today when they say they are only available. Let justice be seen to be done. The only agency that one is able to trace is that somebody somewhere is in a hurry to vacate the conservatory orders that preserve the substrata of the petition on very weighty issues in order to swear in somebody somewhere. Yes, you are concerned with the Constitution. Permit me to point out with a lot of respect, my Lord, your ladyship, I have gone through these things during the radical surgery, and I doubt that we have seen the last of the radical surgery. And my plea is that you preserve constitutionalism, you preserve the dignity of this court, because the people of Kenya are looking up to the judiciary. Only preserve that.
May it please you, presiding judge and members of your court, we thank you for the opportunity to reply as respondents. Before I do that, I want to thank
to find out whether we are with the foreign retail or not.
Yes, how many people are supporting the application? In number 15. Are you parties in this matter?
Yes, we are consolidated. So there's a petitioner, the second petitioner, who has. For the second petitioner, with the support of the application.
Your name?
This is Kemoto Teresia Wanjiro from Test Kimoto and Company Advocates. For the second petitioner. Yes. So perhaps I'm also allowed to submit or go to. Okay, thank you. So, Your Honor, I'm in support of the application. The fact of the matter and why we are in support of it is, number one, as I said earlier, we were never served with those directions. And the fact that we were never served, this is proper procedure. That's any matter that is taken before a judge. All parties must be notified. We were never notified. So why we were never notified, and I had to learn about this issue today, I do not know. That raises eyebrows. And from the petitioner's side of view is, will this bench be impartial? Or will we be hard? Because if directions are being taken, petition E013 of 2024 is part and parcel. In fact, it was consolidated. We have not been notified. Why? Number two, the issue of fair hearing, Article 50, has been repeated over and over again. Isn't this a violation of the second petitioner's right to fair hearing? In fact, some of these applications, I'm getting them now. Yet, I should have been served before. Why the hurry? Why the rush? Why am I supposed to be served right now in court and I'm told 5 minutes submit? What is in stake? Let us all get a fair hearing. And with these preliminaries that are coming up, one is meant to wonder, will we really get justice? Petition E013 2024 was filed before petition E014 and E015.
Council, just for your information, those were your orders you got from Kregoya, where the petitions were consolidated. So that must have been your application before that court.
Yes.
So don't bring it here.
Yes. But the issue is, even after it was brought here, it is being mentioned and we are not aware. So if a matter is going to be mentioned and we are not aware, then it only shows either the bench is ignoring us, or perhaps our petition has no merit, and why so, yet we have not submitted. Let us be given a chance, let us be given audience, even to reply to the issues that are being brought forward. And we cannot reply when standing right now. I need time, I need 1 hour or 30 minutes or whatever, but I need time. So those are the issues why we are in support of this application. We feel that we are not being given a fair hearing. And the other issue that has been raised also, that the bench sat on a Saturday. We are not aware, we are learning right now. We know court operates Mondays to Friday, 8 a.m. to 5 p.m. This Saturday, when was this direction issued? Why were we not informed? So those are the bases why we are now joining hands. Though our petition has its own grounds, but then again, because of those issues, we feel if we don't raise these issues, then we might not get proper justice, because there are some people who, of course, are SDAs who are not able to sit on Saturday, who are not notified again, those kind of issues. That's why we are wondering why the rush. Yes, maybe.
We are on the application for empanelment.
Yes. Yes. That is the issue. The issue was that, and I've also talked about it, we were never informed. And any petition, any case that will be given direction, so long as I'm in it, so long as there's a petitioner there, I have to be heard. And that is the law. And there's nothing new I'm saying. This is the procedure all advocates use. Why is it that I'm being ignored? I'm being notified 11 a.m. watching television, and I was very eager like any normal Kenyan. I see my petition being mentioned. I was very angry, but I decided to take a vehicle from Kirinyaga County quickly to come before this court and inform the court that that is not fair. That is not fair, and Article 50 has been violated. And this being a constitutional court, kindly allow us to participate fairly. Yes.
Your Lordship, in the limited time that you start, your name please. My name is Gachagua. Within the limited time that we start with my learned friend, Mrs. Kimova, and despite all those challenges, we have come up with about 4 points which we request that we be allowed to submit on, since we do not have more time to file documents in support of the application. So kindly, my Lord, give me 5 minutes. Your Lordship, the powers that are given to the Chief Justice to empanel a bench, as submitted by my learned friends, is not a power that can be delegated. In constitutional law classes, which we have the privilege to be tutored by Senior Counsel, Professor Gideon Muigai. He told us that there is a principle called delegatus non potest delegare. A delegate cannot delegate. So that the people of Kenya have delegated power to the Chief Justice to exercise that power. And the Constitution does not leave any room for delegation of that power. So now, we are before you, having been empaneled by a person who does not enjoy the people's power to empanel a bench. Lord, this is a jurisdictional question rather than an administrative question. And from the decisions which have been cited by my learned friends, Kemri, Okiom Tata, and the Conchela case, one thing you learn is that in Kemri and Okiom Tata, the court said this is a constitutional function and it cannot be delegated. When you go to the Conchela case, the court allowed or said that the Deputy Chief Justice could empanel a bench. Again, it went ahead and gave some conditions. I don't want to go through all that. But Your Lordship, what you learn again is that shortly after the Conchela decision was made, an appeal was filed in the Court of Appeal. And who filed the appeal? It is the National Assembly, who is a respondent today. It is the Senate, again, who is a respondent today, urging you to take a contrary position. What was the argument by the National Assembly and the Senate before the Court of Appeal? The argument was the Deputy Chief Justice cannot perform this function. And on the basis of that, kindly stay the proceedings before the High Court. I'm referring to Nairobi Court of Appeal, civil application, number E097 of 2021. So the Senate and the National Assembly went and argued before the Court of Appeal. Don't allow those proceedings to go on before the High Court, because that bench, a 5-judge bench, is appointed by a person who does not have the authority to appoint. And the Court of Appeal considered that application. In the ruling, the court agreed with the National Assembly and the Senate. And the ruling does not have a paragraph numbers, but towards the end, now in finding that the Senate and the National Assembly had an arguable case, they said, as we have observed, an arguable point of appeal is not one that will ultimately succeed. The point intended to be argued, whether the Chief Justice was empowered by the said article, the article we are discussing, to empanel a bench of the High Court, is not an idle one. It's not an idle point. It is an arguable point. The court, on the nugatory aspect, stated that on the nugatory aspect, it appears to us that if it was to be held on appeal, that the Deputy Chief Justice had no power to empanel the bench, the appeal would be a victory with no practical effect and academic exercise. So, the court also considered the third aspect, which was introduced by the Supreme Court in a previous decision, the public interest consideration. And they said, we find also that this is a matter in the public interest domain, and it is proper that the appellant exhaust the appellant's rights. So the court went ahead and said that the motion succeeds and stayed the proceedings in the High Court, and to date, they are stayed. And the appeal was supposed to be determined in a certain period of time. The appeal is still pending, and the proceedings in the High Court are still stayed. So that you are at the place where the 5-judge bench found itself. It made a determination, it was stayed. So today, we do not have any decision where the empanelment by the Deputy Chief Justice stands. Therefore, before we proceed in these matters, kindly find that the Deputy Chief Justice does not have power to empanel a bench of an even number of judges to be appointed. Thank you very much.
Your Lordship and my name is my name is Sakimpa. I asked for the third petition in this consolidated petition, which was Kerugoya E014 of 2024. Your Lordship, I want to begin to say that the proceedings that are before this court today are fruits of a prisoner's tree for the following reasons, my Lord. The first reason is that, Your Lordship, our matter was referred to the Honorable Lady Justice, the Chief Justice, on 11th of October 2024 for empanelment of a bench. Your Lordship, the same has never happened until the conservatory orders in petition E015 were granted. It therefore shows, Your Lordship, that petition E014 as consolidated E013 are here to seal the loopholes so that we cannot question why petition E015 was brought before this court before E014. Your Lordship, I just want to agree with all the submissions by my learned friend. That is my submission.
Can I address? Hearing of matters during night hours. The answer to respectfully, my Lord, that judges can hear matters at all hours. I have done so. The colonial judges had cases at odd hours in the middle of the night, early hours of the morning. I remember appearing before Chief Justice Simpson that gentleman. These would be cases with simple matters, like individuals who want to bail at night because probably have been in the bar, they have drunk a lot, and they want to bail. You rush from the judge's home or the Chief Justice's home, and you would grant a bail. It's a beautiful custom, beautiful practice, and I invite you to respectfully, my lords, that you endorse it in your ruling. It gave justice to people. It was a good practice. Instances like in Mombasa, Your Honor, you would have foreigners who have had children, are still minors, in our local girls, and you want now to fly out with these little children at odd hours. They want to get to work, they want to get to the ships at odd hours, and you rush to a judge at night, and you will give you an order, and you go and stop it. During those days, Your Honor, something that I don't see these days, I wish it could be reinstated. You would have names of the judges in publications, like telephone directories. Their telephone numbers would be there. You would know where they live. You would rush to a judge's home because you know where he lives and so on, and he would grant you orders. We no longer have that type of thing at all. I wish it could be reinstated. It was helpful. It handed down justice to the court. I recall one judge I appeared before, and I think he had me talking to his askaris at night. And he came out, shouted, "Who is that?" Somebody said, "Oh, it's a Kalinwa. He wants to come and be heard." And they shouted at me and said, "Kalinwa, I want you to know I'm not a judge during the day. I can't hear you, the time is over." And I returned and told him, "Judge, the world is shocked to hear, or the country is shocked to hear. You are only a judge during the day, and at night you are not a judge." My Lord, let us reinstate that practice. Say so louder in the ruling. But then, coming to some case, what has happened is completely wrong. Your Honor, the Deputy Chief Justice His powers are set out in Articles 147, 148, 149, 150, 141. He has enormous powers. If a person can become a president of the republic at any time. If you're going to hear his matter regarding impeachment, you should hear it during the day and it should be heard in the practice. It's not a matter that can be heard at all. What the Deputy Chief Justice or whoever it is would have done is to get on phone, to get in touch with the attorney general, get in touch even with the advocates, and ask them, can you come? But it should not have had this matter expertise. This is not a matter that can be had expertise at all. And then also when you look at the Constitution, the Constitution seems very clear. I will refer you to Article 165 of Article 4. 165 of Article 4. If you permit me just to read it to the court. It says that, not 165, Article 144, Article 4, Article 144, Article 4. It says that 144, Article 4. Yeah, if you look at that 144 of Article 4, 144. Yeah, thank you very much. If the Chief Justice is unable to appoint a tribunal under Clause 3, the Deputy Chief Justice shall appoint such a tribunal. So you see very clearly, Your Honor, where the Deputy Chief Justice can act, it is set out in the Constitution very clearly. Now, in this particular case, it is not set out in the Constitution regarding impeachment. It does not confer power on the Deputy Chief Justice at all. If I may also refer Your Lordship to impeachment provisions relating to the Deputy Chief Justice, Article 144, Article 145, Article 150, Article 1B. Those provisions are expressed. Now, the next thing I may wish to deal with is, if you could look at Article 165, Article 4, 165, Article 4. 165 of Article 4. It says that any matter certified by the court as raising a substantial question of law under Clause 3B or D shall be heard by an even number of judges, being not less than 3, assigned to the Chief Justice. Now, before the Chief Justice appoints the Chief Judges, he takes into account a number of things. He will take into account the experience of the judge that he is appointing. He will take into account things like whether it would probably bring a conflict of interest. He will take into account whether there would be objections from certain individuals and so on, but he will not expect to do that at all. He takes into account a lot of things. It's not just an exercise where he writes down the names of judges immediately. He takes into account a lot of things before he appoints the one and so on. Now, in this particular case, Your Honor, this may not have, it's not power that can be delegated. The Deputy Chief Justice at all. It is specifically and expressly delegated to the Chief Justice. Now, with the new technology we have, the Chief Justice happens to be out of the country. There's nothing that stops an individual or the registrar from getting in touch with him and explaining to her that, look, we have got this matter coming up. There is the issue of appointing 3 judges to hear. Can you have your views? And they would probably, she would probably say that, look, why don't you have so and so, so and so, so and so, so and so? And she would actually assign the judges to hear such matters. I would emphasize, and I also treat myself with my other friends, that there has to be miscarriage of justice. The Deputy Chief Justice should not have done what he did at home. Not that you have got anything against her, not that you are alleging that there is something that she did which is not, she should not have done. There is also the issue, Your Honor, when you're dealing with matters of this kind in law, the issue of perception. Perception is important. When a Chief Justice performing, a Deputy Chief Justice performing such a kind of job or exercising such a power, what perception are other people calling together? They may read a lot into what she has done. It may be correct or it may not be correct, but there it is. They may come to a conclusion that, look, the Deputy Chief Justice probably is acting under direction of the executive, under direction of the President. That may not have been done, but that is a possible perception. It sends the wrong perception to people. And when you are dealing with matters to do with the administration of justice, perception is important. What signals are you sending out? And in this particular case, a matter involving the Deputy President of the country is being removed under suspicious circumstances. Is it wrong people to suspect that the Deputy Chief Justice was probably preferred instead of the Chief Justice? Is it wrong people to probably to the chain when they're having their task and dealings that the Deputy Chief Justice is possible that the Deputy Chief Justice is taken because he's a friend of the executive and such things and so on. So to make sure that we do not have such allegations, we stick to the law. We stick to the Constitution. So I emphasize before I sit down that what has happened is wrong, must be condemned, and it should uphold the submissions of my able-learned friends. There is a word somewhere, I think in the Constitution, that the Deputy Chief Justice may perform functions today, or the duties of the Chief Justice in absence. Clearly, that refers to cases where the Chief Justice may be relieved, or the Chief Justice may be sick, or the Chief Justice may be involved in something that is cannot enable to perform the work and so on. Now, in this particular case, nobody has alleged to the Chief Justice for anywhere. Nobody has alleged to the Chief Justice on duty, and nobody was alleged anything that made it impossible for the Chief Justice to carry out her duties at all. Again, I emphasize if I sit down on removal of the Deputy President as stopped everything. And it's something that is making a number of Kenyans entertain us for interesting things and so on. Yesterday, I think it was on Sunday, was when I was sitting in my house, I decided to listen to the word of God on TV, and I sit down. I decided to listen to the word of God from a lady preacher, and she was saying that what is going on now? God no longer has any confidence in the current council. Now, you can't blame her when such things were happening. You can't blame her to have come to the conclusion that the Almighty God and the Lord Jesus Christ no longer supports the current government. because of such things. I ask you very quickly that you have full submission of my young friend, Mr. Kigwe, and his care colleagues. They are able submissions, and it is a beautiful thing.
May it please the court, we will try on the side of the respondents to be precise and concise. Let me start off by thanking Dr. Ogada and Mr. Ongoya for their very kind remarks about the small role I have played in the development of our constitution and law. Thank you very much. I also want to thank Council for the civility that has been observed in the presentation of this matter. And I do hope that the respondents will also remain civil so that we extend the proper respect that the court deserves. I am instructed by the Honorable the Attorney General, a very eminent Dorcas Oduor, our first female Attorney General, and she instructs me to inform the court that she is here because Article 156, sub-Article 6, enjoins the Attorney General to promote, protect, and uphold the rule of law and to defend the public interest.